The broadcast is now starting. All attendees are in listen-only mode.
Well, we are going to go ahead and get started. So welcome, everyone. This is Dr. Lauren Lavine. Many of you know me as the digital dentist. I wanted to welcome everyone to tonight's webinar. We have a great turnout tonight. We had close to 500 people that were registered. I think we obviously hit a very important topic tonight, and I'm really looking forward to the presentation, and hopefully all of you are as well. Many of you have been on the previous webinars in the past, so you know how the routine is. You should all have a little GoToWebinar control panel. You can go ahead and type in your questions as you think about them. Now, in the past, many of you that have been on these past webinars know that it tends to be a little more rigid, that I'm moderating, the speaker will talk for 40, 50 minutes, and then we get to the questions. But for those of you who have been on the webinars that I've done with Rohit in the past, you know that it's a little more casual environment with these ones. Both of us will be talking. Rohit's going to do most of the speaking, but I'll be interjecting, and it's a little more interactive than what we've done for our other webinars, and I think that's a good thing, and hopefully you'll all enjoy that format as well. For those of you who are interested in possibly getting CE credits for this, we do offer AGD Pay CE. Unfortunately, it's not something we can offer for free. It's $89 for 1.5 hours of CE credit. You'll all be sent information about that. It usually takes somewhere around a week or so for me to get it all set up and put up online and all the regulations that are part of that. But you'll all be sent information about that if indeed you want that. So just a quick introduction about myself and about our other speaker tonight. Many of you may know that I did practice as a periodontist for 10 years. What I do today is to work with offices who have questions about technology, whether it's digital x-rays or cameras or data backup and disaster recovery. One of the topics that has been really very hot for my business and for a lot of our clients is HIPAA and the high-tech regulations, and we'll certainly talk about tonight how there were some brand new final regulations called the Omnibus Rules that have kind of changed the equation, and I think that's why most of you are here as well. So that's really our goal, to talk about as much of that stuff as we possibly can this evening. Now, as much as I do lecture a fair amount on HIPAA and high-tech, I certainly would not call myself an expert at this point. Fortunately for all of us tonight, we have Rohit Joshi, my friend, who is very much an expert on this. He's held senior executive positions with all kinds of life science companies and technology companies, both in the U.S. and Canada. He's got a bachelor's degree in molecular biology, a master's degree in medical science, and he's also an attorney. So if there's anyone out there who really is, in my mind, an expert on this topic, it's Rohit, and it's a thrill for me to have him back here this evening as well. Just to give you just a brief overview of what we're going to be talking about tonight before I turn the mic over to him, we'll certainly talk a little bit about HIPAA. As I said, many of you have probably been aware of HIPAA and high-tech, especially since a lot of the regulations came about in 2009. But with the new Omnibus changes, and these actually were announced and were supposed to go into effect March 23rd of this year, and you had a 6-month moratorium, well, basically until September 23rd to implement it. And I would venture that if most of you on this call, or like most of my clients, you have not implemented those changes. So it's a good thing you're on tonight. This is not like OSHA in the past where you get a little bit of a slap on the wrist if you don't comply. There's some major penalties and fines and even criminal prosecution if you're not following the HIPAA and high-tech regulations. So we'll talk about the new regulations as well. Talk about a great way to get you and your staff involved in starting to implement this stuff as well. And certainly talk about some of the compliance solutions. One area that we have found is really lacking for a lot of practices is how they communicate with each other. And unfortunately, a lot of the practices we work with use email. It's very comfortable for them. But if you're not properly protecting that information, and typically we're talking about encryption of that data, you are definitely in violation of HIPAA regulations. So without further ado, I want to bring Rohit in as well. And again, I will be probably interrupting him, hopefully not as much as I want to, but at least so we can make sure we get people's questions answered, and I'll be with you throughout the presentation. So welcome, Rohit. I'm going to turn the screen over to you, and we're looking forward to tonight's presentation.
Thanks very much, Dr. Lavine. It's a pleasure to be back here. I think as you mentioned, we've got quite a topic tonight. I think there's been a lot of interest that certainly has come into our business in terms of the new HIPAA requirements. And I think that the requirement really of understanding how they've changed what people have heard in the past, and that's what we're going to try to focus on. I think to make it very practical, though, what we're going to try to give everyone here on the call an idea of how to start and how to take the first steps to get HIPAA compliant, especially in light of the new Omnibus Rules, which have really upped the ante in terms of what people need to be concerned about, the level of fines, the level of that might occur. So, you know, for those who haven't done much around HIPAA yet, the HIPAA laws really, in large part, determine how patient information is held and how it's kept. And it can be a little bit of an acronym soup. You know, we've got HIPAA, there's high-tech laws in Canada, we've got PIPEDA laws, and then in addition to that, there's a lot of state and provincial laws which also govern patient information. But to be honest, I think if we can follow the omnibus guidance, we're pretty much covered, as far as I can tell, with almost every state and province. Now, what some bodies do is they might make some things very specific around provincial regulations or state regulations. But let's, for now, just focus on the omnibus rules. What we're talking about here is protected health information, and it's any information that's individually identifiable health information. I think there's about 15 different criterion that people look at when we're looking at protected health information, including someone's name and birth date and face and so on. So we'll be considering all of those protected health information bits as we go through the rest of the talk. Now I'm going to shock you a little bit with this next screen. And I do that only because there's lots of detail around HIPAA, lots of detail around Omnibus, but I'm going to try to do my best, and Dr. Lavine, expecting you to jump in here, we'll do our best to really make this very practical and very easy to implement after we all stop talking here. As a part of it, I'm going to talk about just these requirements in a broad brush. First of all, encryption is one of those requirements around HIPAA, and there's lots of detail around what encryption is, and I'm going to talk about it a little bit later. But it has to do with the ability of your system to obscure what the actual information is by applying a mathematical formula. And don't worry about the details, I'm going to get to those later. The other very interesting element around HIPAA is there needs to be some level of audit control. And what that means is if a patient's data is being reviewed or looked at or communicated, you need to be able to identify who looked at it and when they looked at it and why they would look at it. And so this becomes a bit of a nightmare if it's left uncontrolled. So we've got some ideas and some strategies, and most of all some software tools that help you do all of that stuff. As you'd expect, there's also data backup and storage and data disposal elements as well. You know, as Dr. Lavine said, I spend quite a bit of time talking about the HIPAA regulations, and I think it's important to really call it out in terms of doctor-patient confidentiality. You know, I don't think I wouldn't have any trouble talking to the same people here on the call today and saying it wouldn't be right to post a patient's private information on a bulletin board in their office. Because we understand what that is in the real world, it's very easy to understand why we wouldn't do that. The real challenge when we start talking about the electronic world is that we might be disclosing information without ever intending to. And that's an important concept, and we'll talk a little bit about that later. But using email, for example, or using services like Dropbox, that information is exposed, and it is public, although it might be a little bit harder to look at than a bulletin board. The same principle applies in that those people who are looking to try to access that information absolutely could. So we're going to talk about some of the ways that we can keep that information safe. So the omnibus changes that came in, as Dr. Lavine mentioned, they came in into effect on March 26th, and then September 23rd, so just over a month ago, it was required that there be some compliance. And like Dr. Lavine said, and certainly my experience with many practices, is that people have yet to even start. So it's something that's increasingly important. As far as the omnibus changes go, the press release on the product or on the changes to the law were called sweeping changes. In fact, the most sweeping changes to the security rules since they were first implemented. So that's why people, I think, are really paying attention. There is something new here and something that's important. One of the big changes, and something that we've certainly noticed, is that there's a lot of information about the expanding digital age and how we're going to protect patient data in that digital age. And we'll be talking a lot about that over the next hour. So when, unfortunately, again, we only have an hour and a half today, and I say that a bit tongue-in-cheek. I'm not sure that anyone would want to listen to a lawyer talk about the omnibus regulations for much longer than that. So I suspect it's probably okay that we only have an hour and a half. But what's going to happen is there's going to be lots of questions that come from that you might have. So please enter those into the webinar box, into the control box there, and we'll do our best to answer those throughout the rest of this session. And then what we've committed to doing is both Dr. Lavine and I will look at those questions afterwards, and we will email out to everybody a summary of all of the questions and all of the answers that we've been able to come up with, both the ones you hear and the ones we weren't able to get to. As far as the omnibus summary goes, there's really three big areas that we're going to be talking about today. Those are in terms of privacy, security, and breach notifications, the notice of privacy practices, and the business associate agreements is kind of, it's my take to some of the things that have changed significantly. So here are the ones that are really probably going to impact your practice. And we'll start with an easy one. One of the things that the Omnibus Rule changes is that if a patient asks for you for a copy of their protected health information, which basically is their medical record, and of course their dental record, you only have 30 days to respond to that written request with the Omnibus Rule. Now there is an opportunity to have a 30-day extension, but usually that's going to be reserved for files and data that might be kept off-site. So it's really to focus on that 30 days. Now the good part about this is that you only have to provide hard copies if the patient rejects e-formats. So you conceivably could give it to that patient in an e-format, and they would be, almost not obliged to take it, but perfectly well within their rights. Now, emailing PHI is something that's pretty interesting because it's something that we take a very strict view of, from doctor to doctor communication or doctor to lab communication, because we believe, and the laws back us up, in terms of that information having to be encrypted, as Dr. Lavine mentioned earlier. Now, what the Omnibus Rule allows is if the doctor would like to communicate with that patient, it actually can be done in an unencrypted email, but before you can do that, the patient must be advised of the risk and still requests that form of transmission. So it's a nuance. It's something that you, of course, want to get consent for this. It would be something that you would have to inform them of that risk, and then you're allowed to transmit. And we've got an interesting solution coming, in a few months around that, but I won't go into that for this call.
Hey,
The next, yes, sir.
I just wanted to add one thing here, because we work with a lot of practices who don't have an encrypted email solution, and their solution has been to have the patient sign a waiver saying that it's okay to send unencrypted information to another office. And my understanding, you can correct me if I'm wrong, is that that's not legal. The patient can waive their right to have encrypted, to have non-encrypted information sent to them directly to the patient. They cannot waive the requirement that you send information to another office in an encrypted format.
That's a great point, and that's exactly my reading of it as well. If you want to send information to, if your practice wants to send information, patient information, to another practice or to a lab or to someone else that needs that information, it must be done in an encrypted manner. You do not want to send that in an unencrypted way, because you're the one that's going to be held liable. Now, again, it's okay for you to be able to send that to the patient, and then they, on their own volition, can send it to that practitioner. That's a way around, but I'm telling you, it's not worth it. I would not touch that at all. You do not want to get in the middle of that type of transmission. The breach notifications, and these are, this is the obligation to notify the patients. There's this particular element is one that has been expanded in the new rules, and it's interesting because now we're starting to look at breach notifications in kind of a multi-part test, and that multi-part test looks at who the information was sent to. It looks at what type of information was sent. It looks to see if the person or that person who received that information has a confidentiality agreement anyways about that patient. So there's a number of criteria now which will really test how bad this breach is. But it's one that's reasonably complex. The good news about it is before it was a lot looser, and if there was any notification, there was a very strict, you must notify all the patients. There's a little bit of opportunity now to say, well, if for example, you sent a file to another dental practice, but it was the wrong dental practice, it's very different than if you sent the file to someone who wasn't bound by HIPAA. And so it takes this type of thinking into account. Now, there's quite a bit of detail around this, and again, if you're interested, put that in the question box, and we'll get back to you, some more details about the breach notifications. The last one that I think is probably worth spending some time on here is in terms of marketing communications, and this is a big one because there are a number of dentists and a number of services out there where doctors might be communicating to patients using a product. So the new rules, again, are quite detailed, and it's something, again, if you're interested particularly in this element of it, write us a question, we'll send you some detail out. But a quick summary of it is you can only market to your patients if, first of all, they've authorized that communication. If the doctor does not receive any compensation in this, if it's a face-to-face communication versus an email, it's a different regulation. If you're communicating around a treatment or something that's currently prescribed, you're actually able to do that as long as you're not receiving compensation for communicating that very specific thing. What we've seen is it's still okay to promote general health through, for example, an email. But in that type of promotion, you can't mention a product name. And the last element that they look at is, is it something it's a government-sponsored program? And if that's the case, then it's okay. And one thing they make very specific mention of in the Omnibus Rules is that you're still able to give patients promotional gifts of nominal value. The big question as to what's nominal value. I think in many practices that I know routinely give out toothbrushes and toothpaste and dental floss. I would say those are absolutely still nominal value. The example that I've seen used is you can give away pamphlets. So you could give away a pamphlet of a certain product that you're interested in, but you can't actually, if you're getting compensated, send that to them in an email. So it's quite a bit of nuance around this, and one that I'm sure there's going to be lots of questions about, because to be honest, this one took me quite a while to wade through the regulations and then really try to find a way of applying that into the dental practices that I'm visiting on a daily basis. Now, the second slide of changes, to be honest, I don't think is that relevant for us to spend too much time on. It's the sale of protected health information. So, should you be able to sell the patient data, childhood immunizations? Can you charge for your copies of protected health information that you're making to the patient? And research authorizations and other elements. So there's, again, lots more. There's over 500 pages of stuff you can read. But I think those first four on the first slide that I presented on Omnibus Rule changes are really the ones that are going to be the focus point. Now, one of those things that is required for your practice is you have to develop and distribute a notice that provides an explanation of your rights and practices within your clinic. So what we've done is we've found one that you can actually make copies of. You can make it available to your patients, and you can post it on your website. You will want to go through it, obviously, and that's part of our action plan, is you want to make sure that you're complying with everything that you're saying you are. But once you've done that, you can publish this on your website. You can give it to your patients if they come into your office. And so this is part of the package that we'll be providing to you on follow-up. The other very large change that we've seen is around business associates. So business associates are typically people that may work inside of your organization or work for your organization and have some connection to the patient information. So an example of this might be a CPA firm that, for example, has to do some work with while disclosing who your patients are, what their treatments were, and what they were billed. All that would be considered protected health information. And so your CPA firm, in those cases, would be considered a business associate. You need to have agreements with business associates so that they are bound by the confidentiality that you've assumed for having that patient data. Other examples might be your practice management consultants who might come into your practice and may have access to your Dentrix systems or your practice management systems, or maybe advising you or analyzing patient data. You want to make sure that you have signed agreements with them so that they keep that information private.
Hey, Rohit.
Yes, sir.
We're getting a few specific questions about that. Someone asked about an IT services, if they're considered a business associate, and I would say absolutely.
Absolutely,
we have business associates with a lot of ours. But what about other dental offices and labs? Because my understanding is that those are not considered BAs. But could you expand on that?
You're absolutely correct. And the way that the HIPAA describes that sort of group of people is if there is someone that's required for the treatment of the patient, then they're not considered a business associate, usually because they're bound by their own HIPAA regulations, right? So if you're sending a patient over to another dental practice, that information, that the dental practice that they're going to is also bound by the same rules, so they wouldn't be considered a business associate in that example. Now, it's really interesting you mentioned labs, because when I've been doing research, I've got differing views of that. But, I think it's safe to say that you probably don't have to have a business associates agreement. But, from my point of view, better to be safe. And I've got labs that do have them available now for their dentists so that there's no concern. but they might be simply covered because they are providing part of that treatment. One interesting element of this is that there's people that might be working within your practice who might be contractors. So for example, you may have a hygienist who isn't an employee but comes in and works with you, with your practice, under a contract. Those are people that we would call agents and not independent contractors. You want to make sure that you have agreements with them as well. And it's a bit of a nuance, and it's something that's changed a little bit, because I know that in previous examples, people haven't really considered that to be an agent of the practice. They've actually considered them to be part of the practice and therefore covered. The new Omnibus Rule makes a little bit of a distinction there. So if I were you, I would get them to sign a business associates agreement. It serves no harm to do it, and it just confirms that you are in fact making sure that they keep all of that information confidential. Enforcement and penalties. This is a part of the Omnibus Rules which has gotten some further attention. One, because the breach now has gone much higher. It's gone to $1.5 million at the highest end of the breach. There's 4 tiers here, and unfortunately it looks like there's only 3, so I'll go through it a little quickly. The first one, the lowest tiers, is really where the doctor did not reasonably know that there was a breach. And the category, the way I've seen it described, is not knowing. You simply just did not know that there was a breach. Now it can be said that there's examples for each one of these. Dr. Lavine, I don't know if you've got an example of this, but one of the examples that comes to mind for me is where someone's data may have been breached and they don't know, simply because there was no mark left on that data.
We see that all the time. I mean, we have companies that work with IT companies like ours where the IT company went in without their knowledge and worked on the system, and obviously, maybe if they didn't have a BA agreement in place, or they just weren't aware of what the IT company was doing, and they just had no way of knowing, because no data was taken, that the server worked fine, everything was fine, but they weren't using software that they should be using to track who actually is logging in, so that they can audit that and be aware of these breaches.
Exactly. Yeah, that's a great example, and I think in that case, with a business associates agreement, what that ends up doing is putting the obligation on your IT company to make sure that they're doing all of that logging and all of that reporting, because you might not know. The second tier here is called the intermediate, and these are cases where the doctor knew, or if they would have poked around a little bit, they would have known that there was a violation. And so an example of that might be, and again, there's a different distinction between that and the highest tier, which is called willful neglect. I'll get to that in a minute. But the intermediate tier really is about a doctor who's busy in their practice, everybody's doing their job, and if the doctor would have poked around a little bit, he would have noticed that there was breaches going around. But it wasn't that he knew there was breaches and just ignored that fact. And so it's tough to kind of prove. It's a difficult one because there's so much information now about what HIPAA is, about the Omnibus Rules and everything like that. It becomes difficult to say that I didn't know. So Dr. Lavine, I'm not sure again if you have an example of this one, but this is a tough one to really describe. I don't know if I've got a good example of this.
Yeah, that's tough. I mean, perhaps maybe you come into the office and you notice that there's a thumb drive plugged into a computer that shouldn't be there, or that it wasn't there before, and you're kind of like, well, why is someone copying information onto here? What's that thumb drive doing there? Something like that to me would be a bit of a red flag. But it's that's the only thing I can kind of think of that would maybe go into that intermediate tier.
That's a great example. You know, I mean, if as we've talked about in previous webinars, the single largest cause of breach for dental practices is the loss of information through stolen laptops, or lost thumb drives. So that's a great example. The final one is called the highest tiers, and that's where in cases where the doctors acted with willful neglect. And unfortunately, I would say that this is probably more common than I'd like to talk about. I go into a lot of practices. Well, actually, the ones that I go into, people recognize that there's an issue. It's the thousands of them that really are putting a blind eye towards HIPAA and the Omnibus Rules. This one is cause for the biggest fines. The reason there's 4 tiers here is because if you've been neglectful, if you've acted with willful neglect, and you can correct the problem in 30 days, that's considered a tier. And your fines are going to be at a minimum $10,000 and a maximum of $1.5 million, depending on how willfully you have neglected that and how big the breach was. The difference is that if you've been notified that there was a problem and you were not able to correct it within a 30-day period, the minimum fine is now $50,000. And that goes up to $1.5 million as well. So those are the type of things that we're starting to see. Because there's been this much focus put on enforcement and penalties, I think it's foreshadowing the fact that they've got enough experience now with the HIPAA laws to understand how to get through them so that enforcement really sticks. And, you know, the American Medical Association recently came out and said, you know, this is something that everyone needs to start taking a very timely look at. Now let's get beyond the gloom and doom. I think that, you know, one of the things that, you know, Dr. Lavine and I have talked about in previous webinars is none of this is meant to be confining for you, because if the only thing I communicated was, you know, your life is over because of HIPAA and Omnibus, we would have done the wrong thing. The whole idea here is to try to find something very practical, and we can engage very quickly in solving some of the regulations and getting your staff up to speed. So the first step is planning your first HIPAA meeting. And we'll go over an agenda here in a minute. So in order to help you with all of these things, what we'll be providing back to you is a HIPAA compliance checklist. And that's going to provide your practice with a list of things that you can go through and say, do we do this or do we do that? And so that you can get on side reasonably quickly. And to be honest, most of the things are not very big. They're things that are common sense once they're shown to you. It's one of those things. You might not have thought of it, but once you see it on a piece of paper, it's not that hard to do. The second is a little more complicated. It's a HIPAA software checklist. That's something that you're going to want to send to your IT companies or your other people that you're buying software from. And we've geared that specifically towards some cloud vendors. And we are Bright Squid, Dental Link, and Secure Mail are a cloud vendor. And so we've started to see quite a few things happening on the cloud that we think a checklist is the right thing. So it's a list for all of you to be able to challenge your vendors and make sure that they are HIPAA compliant. The next thing that we're happy to provide to you is, you know, we've done 3 previous webinars on HIPAA compliance, how to get started, your 5 things that you do every day that are not HIPAA compliant. We would recommend that you have a look at those and provide that information to your staff. We'll also provide you with a patient privacy brochure, a notice of privacy practices, and a business associates agreement. The patient privacy brochure is something that we wrote up to make the discussion with your patients very easy. So let's go through what your first meeting is going to look like. For starters, we want to get everyone aware and educated. We want you to start the conversation with your practice. Get your staff together. It could be over a lunch meeting. It could be separately. But get your teams talking about it, because that goes directly to, whether or not you've been willfully neglecting HIPAA. And so from that perspective, what we're going to see is if you can get your team to watch one of our previous webinars, you'll find them, again, very practical. We cover some good information and some real examples of how things that they can do that make sure that they get started in HIPAA compliance. We'll also provide you with the review the Notice of Privacy Practice document that we provide you. Again, that's something that you're going to have to provide to your patients, and we'll provide you a sample one. And the last one is the patient privacy brochure, and that's just a summary of information that you can provide to your patients. The second big bullet is complete the HIPAA checklist, and usually what I would do here is you would want to designate a project manager. It might be your office manager in your office. It might be someone else on your team, but someone who's really responsible for completing this checklist and making sure that you can get HIPAA compliant, or that at least they can do an assessment to see where your practice is. And that's that checklist that we are going to send you as well. But make it very practical. Assign a project manager and let them get started. The third one is send that HIPAA compliance software checklist to your other vendors to make sure that your business associates are signing the business associate agreement, as well as keeping their software, using their software in a manner that is compliant with HIPAA regulations. And the last element is really just to determine a timeline. You're going to have lots of stuff to do. None of them should take too long, but you want to keep track of it so that in 30 days or in 60 days or in 90 days, you can set that goal for your team and say by 2014, by the new year, we're going to be HIPAA compliant. Again, baby steps, but let's get started.
Hey, Rohit.
Yes, sir.
The first line you had there was about reviewing the Omnibus Guide. Is that something that's being sent to them as well, or is it just getting all the forms?
Yeah, it's just getting all the forms. We've modified all of our forms now to match the Omnibus rules.
Okay, but everyone on the call will be sent that, correct?
Absolutely, yeah. Everyone on the call.
Great. Okay. Great.
Yeah, you bet. The HIPAA compliance solution. So we're going to talk a little bit about email, because I would say that along with thumb drives and stolen laptops, the biggest thing that we see is emails sent between labs and between dental practices, whether that be a patient referral or a consult, or whether that is sending information to a lab. Email is used quite a bit, and that's a problem. Again, this is one of those things where because the post is quite secure, we automatically feel that email might be. But email actually works in a very different way. What happens with email is when I send it from my computer, even if my computer is secure and I'm trying to send Dr. Lavine an email, it's bouncing off of servers around North America before it ends up on Dr. Lavine's computer. Every time it does one of these bounces, those servers can be, or the email can be viewed on any one of those servers. And it doesn't have, and because those emails can be readily viewed, they're not secure for patient information. So systems like Gmail, like Dropbox, like Hotmail, like Outlook, all of those systems are not compliant. I've got a couple of other examples here. We've got examples like Apple Mail, Dropbox, SkyDrive. I'll tell you the number of Dropbox users that I've seen when I go into a practice, because they want to share their cone beam CT scan, or they want to share a large amount of data that you just can't send in an email. And frankly, Dropbox isn't HIPAA compliant, and neither is your email. So you want to be searching for a different solution. So, I would say that this is a typical email that I would see. It's communicating with a lab. It mentions a patient's treatment, although it's spelled wrong. It's mentioned a patient's treatment, and then includes a number of images. It also, to make things a little bit worse, talks very much about the treatment that's actually going to occur. And so this type of a message is absolutely not allowed because it's bouncing off of all those servers. It can be read at any one of those servers. And moreover, remember earlier when I talked about HIPAA compliance, there's no log or auditability of this information. So it's actually bad from a number of fronts. Our product is called Secure Mail, and we've done a number of things in our product that makes our system compliant. And I'm going to show you a demonstration of the system in another 5 minutes or so. And the demonstration is pretty straightforward. It is simply because it's just like email with a few advantages. The first is when I put in someone in the To field, it actually will show up with their picture. So they have an account on our system, on the Secure Mail system. They have their image put on there, and when I type that person's name in, it gives me visual confirmation that it's going to the person that it should go to. And I don't know how many times I unfortunately even have sent email, regular email, where Outlook has automatically completed the address of the individual, and it ended up going to a wrong person. What we wanted to do with our system is give that secondary check. The subject in our system is the same as the subject in Outlook, but it happens to be secure. We've got an interesting a split in our product, and I'm going to show you this live, but the top half goes to their regular email. So this information goes to the email that they're already monitoring for everything else. This does not require a new email address. So this information will end up in their normal email, and what will happen, and I'll show you this, is there will be a link in their normal email that will then expose them, it will expose to them all of the detailed information, all of the images, all of the treatment specifics, as well as the person's name. We also, one of the other benefits is that we do allow 500 megabytes per message, as opposed to maybe 10 megabytes or 20 megabytes on your typical system. What that allows is you can send very large files, including whole cone beam CT scans through Secure Mail, or you can send multiple high-resolution images, and I'm going to give you a quick example of that. This is just a quick example to show you how this looks in Outlook, where we do have something that's coming here in to my regular email address, and then I can simply click on this link, and that goes to the secure part of the mail. But rather than spend too much more time talking about it, what I'm going to do here is actually load up my system and show it to you live. Okay. Just be another second. All right. Dr. Lavine, can you see my system there?
Yep, see the login screen.
Okay, perfect. So what you see here is a typical login screen. This is our demo environment, demonstration environment. And what you'll see here is we've created a doctor called Pierre Fauchard, and I'm logging in as Pierre Fauchard with my own password. This is available for Mac or PCs or your mobile phone or your tablet, because it's a website. As long as you have access to the internet, you can access our site. So I'm going to write a quick message, and we'll show you how easy it is really to share information. So in this case, I'm going to compose a message. I'm going to write this message to one of the other people on my system, and his name happens to be Edward. And you can see I type in part of his name, and it comes up with Mr. Edward Engel, and it's a lab. So we have of course a directory in our system. We can easily we search that, and Edward's name comes up. You can see here his pictures there as well. It might be quite small on your screen, but his picture's there, so I can confirm in fact that it was meant for Edward. In the subject line, I can actually mention the patient's name because that part is kept secure. John Smith's photos and STL images. So I can enter, this is the part of the email that will go to Edward's regular email. So I will write here, this is regarding the patient we spoke about this morning. So I haven't mentioned the patient's name because this part of that email is unsecure. Here's the secure part. So I can say, John would like treatment. And I'll say something quite easy just so I can get it there. Now what I'm going to do is I'm going to drag and drop some images of me into that. Not that my name is. There we go. So I can drag and drop images pretty quickly. It's quite easy for me to actually pick a number of images and just drag them to that area. They automatically upload. So while this is going on, I'm going to prepare to just send the message. This is going to be sent securely. As soon as I hit the send button, it will send the secure, it'll prepare the secure message, and it will send this part of the message to Edward Engel's normal email address. And that's it. And so that's as easy as email gets, and sometimes it's quite funny for me to talk about giving a demonstration about email because it should be exactly as you'd expect it. It works just like email. Now, here's an example of what something might look like if I received it from Edward Engel. He sent me a quick message, and here's all of the images that he has sent me. Now, as the doctor, I can have a look at those images. You can see that they come in quite high resolution, and I've even got some interesting tools that I can use, and I can say, not quite Edward. So we enable the use of some tools that will allow you to mark up these images. One of the more interesting things that we also allow is if Edward Engel had sent me a 3D STL image, I'm able to view that image, I'm able to rotate it, and this is all included as a part of the secure mail. I can even get away and have a look at that occlusal surface just by doing that. So this is all included as a part of secure mail, making it even that much better than a typical email system. So without going into any more detail, you sort of get an idea here of how to create an email, how to read an email, and I'm just going to jump us back into the slides just to complete a couple of more thoughts. So a little bit more about our company. We've been on the market for just over 18 months. We're in 10 countries, over 2,000 users, well over 50,000 patients now, and 800 to 1,000 files per week go through our system. We were just checking today. I think we typically get between 10 and 20 new sign-ups a day, so things are growing pretty fast. It's pretty exciting for us. We have a number of publications that have been written about us. You might have found us in Dentaltown or Inside Dentistry, or even a podcast where I was talking a bit about a product and how to collaborate in an environment of patient privacy. So I'd encourage you to go to our website, and you can find all of these links there so you can do some more research about our company and about what our goals are. Now, one of the things I wanted to do was just talk a bit about the offer that we're giving to everyone on the webinar today. It is for, normally our secure mail service costs $39.99 a month, but as a sign of appreciation for you coming to this webinar, we're offering it at $29.99 per month until November 15th. So if you're interested in secure mail, you'll want to get on it and sign up before November 15th so that you can get the discount. And that's $10 a month of a discount for as long as you use the product. In order to get that discount, you'll be prompted for a code, which is Lavine. And so it's very easy. You can go to secure-mail.com, hit the sign up button, click on where it says dentist subscription for monthly, and it'll still say $39.99 per month there. But then when you enter the coupon code, you validate the coupon and hit the buy button, it'll convert it to $29.99 per month. I think that is the end of the show, Dr. Lavine. So I'm open to questions.
Yeah, when you say the end, you mean the end of you presenting slides, because
Yeah,
you're not
right.
going anywhere. We got a bunch of questions.
Okay, and
So,
great, excellent.
We got as I said, there's at least a dozen questions on this one topic, on the secure
great.
mail. It's in two parts. Number one, if the office you are sending to is not using some type of encrypted email system, what is your liability, if any? And secondarily, if the other office, if you want to basically get them to be part of your network so that you can send these secure mails, what does it cost for them to be part of that network?
Oh, okay, great questions. So we made a decision early on when we were promoting the product. We didn't want to charge by gigabyte. You know, you have a certain number of gigabytes. We didn't want to charge by message. We wanted to charge by subscription. And so you can send as many emails with as many attachments as you want for the monthly fee. Now, as a part of that monthly fee, what we wanted to do is make sure that you've got your top contributors, the people that you communicate absolutely the most with, as a part of that community. So not only do we cover you, but we cover your communications with up to 25 people. So typically a practice, from what we've seen, typically a practice will have 3 or 4 labs that they want to communicate with. Some is maybe even as 5. And they'll have 5 or 6 specialists that they want to work with, and maybe a few more for their study club, where they want to talk to their groups. All in all, I would say that most of our practices have HIPAA-compliant secure mail communications with about 15. But we've gone ahead and given everyone 25. So you can really invite 25 people to your community, and we cover all of their communications from you to them, from them to you.
Not talking specifically about the secure mail system.
Yeah.
If you're using secure mail and the recipient is not, and chooses not to for whatever reason, what is your liability? Do you have a liability, or is it basically you've sent something secure, and if that office takes those images and loses them or whatever, that that's not really part of your responsibility?
Yeah, if we're not talking about secure mail specifically, that really is their obligation. But as a part of your obligation, you need to communicate. You need to log the fact that you have done everything correctly. So if you're using the secure mail system, for example, all the auditability around all the logs are there. You can prove that you've done things correctly. If they've done what they're going to do, unfortunately, that patient is still probably going to come back to you, because you are the person that signed the consent form. Now, you will be able to transfer that liability to that other office, but in that patient's eyes, it's more of a business question, I'd say, Dr. Lavine, rather than a legal question. You've transferred that liability to them, that's fine. The nice thing about how we're doing secure mail, though, is you can simply invite them. They don't have to buy their own account. They're all covered. And so that kind of covers the person who bought the account. And that was kind of our view around creating this type of a system.
So no charge at all for those
No,
25 people.
no charge at all for the 25 high contributors that essentially you're giving a free subscription to so that they can communicate back with you.
Okay. What about clearinghouses? Are they subject to this as far as you know, and is there a way that someone would be able to check if the clearinghouse is compliant with HIPAA regulations?
It's clearinghouses absolutely must be compliant with HIPAA regulations. You can ask them for their for a business associates agreement, and they will give it to you because they are absolutely covered under the regulations.
Okay, someone here is asking about where they can get the NPP to post in their office, but you're going to be providing that to everyone.
Yeah, we'll send that to everybody, and as well as sending everybody a business associates agreement, a template that they can use for the people that they're speaking with.
Okay. I'm not sure if I completely understand this question, but I'll just read it as it is. Does our release for records form need to state the advised risk and form of transmission?
I think what that might be referring to is if you're communicating with the patient, sort of this might be, for example, at the end of a treatment where the patient might be signing a release, and if they want all of that information sent to them by email, absolutely, you would want to make sure that the method of communication, and as per the new Omnibus Rules, also a very clear understanding of the risk that they're taking by having you put it in email. That would be what you'd want to have on that release, so that you don't incur any liability in that process.
Okay. What about if someone wants to get the secure mail, but they're a specialty office, and obviously a lot of specialty offices communicate with significantly more than 25 other offices.
Sure.
Is there special pricing for them as well?
Yeah, we have a specialist's subscription. It has unlimited connections, so there's not the 25 sort of the closest. We have specialists who have large offices who have over 600 referring dentists, and because of that we have kind of an unlimited approach to referring GPs. So all of the referral network gets a free account to send you information, and seems to work quite well. That account, depending on the size of the office, varies because there might be 2 or 3 or 4 specialists, and so it decreases with each specialist. But if you just want to give us a call or sign, you could even write it inside the message box that you have on this webinar, and we'll call you back and do a custom have a one-off discussion depending on your needs.
Okay. We've got so many great questions here. What about how long do they need to sign up for? What's the minimum contract length?
Monthly. There's a lot of other services that sign you up in long multi-year agreements. Again, not our intention. We have done so well by just providing a monthly subscription that we're going to stick to that. Now, if you pay yearly, there is further discounts. So if you want to just pay once, we'll give you a discount even further than the $29.99 a month with the Lavine code. But no, you can cancel at any time, and we'll refund your money if we've charged you for a year.
Okay. And what about the Omnibus Guide? There's no charge for that. All the stuff you're sending them, that's free.
Yeah, absolutely. I think that is a part of what we're trying to give back to your large community, Dr. Lavine, and hopefully our large community as well. Is we're in a privileged position because I think I spend a lot of my day trying to understand this so that I can help practices get up to speed, and we provide that to our community. We're very happy to do that.
Okay. We've got some really great questions here. Some tough ones too, I think. But,
save those for you. Yeah.
Yeah. Patients can request an appointment through our website. It comes through email to our office. Is that a problem?
I would say that is a problem. There are some patient portals out there that do encrypt that information, and so it's provided to you securely. But because it's patient initiated, it's not a huge problem. The bigger problem comes is now that it's in your email, what are you going to do with it? Because now you have to store and encrypt that data. And you shouldn't be communicating back with them using a normal email system. So it compounds the issue if it comes to you by email.
Okay, I agree. Does my practice need to have a written log of possible HIPAA discrepancies in our solutions? My answer, and you can correct me if I'm wrong, is yes. This is one of the services that we do for our clients. One of the rules of HIPAA says that you're supposed to do what's called a risk analysis, where you basically go through, Rohit showed that slide near the beginning where it was all the different HIPAA subsections. You really are supposed to go through each one of those, make sure that you have all the written policies and procedures in place, and obviously correct that. Am I incorrect about that, or is that
No,
correct as well?
You're absolutely correct, Dr. Lavine. I think what we've done and in the package that you'll receive is something called the HIPAA Checklist. And what that's meant to do is just it provides you with a basis of where you're compliant and where you're not compliant. And so you can just go through this checklist, you can answer the questions, and that's sort of your starting point. Knowing how far you have left is a lot better than not knowing at all. And I think the regulators take that same approach. So what we've seen in some of the enforcement is the people that are coming to enforce, if you've taken a few of these steps and in trying to become HIPAA compliant, they're extraordinarily understanding. Where they get very upset, like the biggest fines that I've seen are where people just ignored it. Didn't have a meeting, didn't talk about it in their practice, knew things were going on, but just thought it would never happen to them, and so never worried about it. Is that your experience as well, Dr. Lavine?
Absolutely.
Yeah.
Does HIPAA limit itself to EPHI? If someone only uses first-class U.S. mail, for example, are they still considered a covered entity? Has the Omnibus changed that at all?
No, it hasn't. So HIPAA is every practice in your every type of practice that happens in your office. So HIPAA has something to say. For example, when I first started looking at HIPAA in the late 90s, I would walk into a doctor's office or a dentist's office that was in a mall, and everybody that was walking by that office could see on the computer screen who the patient was, because the monitor was facing the outside hallway. That is covered by HIPAA, because the basic premise being that if anybody can view the information that shouldn't have access to the information, there's a violation. And because anybody walking by in that mall could see that, there was violation. Another great example, and something that really hits home for me, I would say 10 years ago even, when I was going to go get a prescription filled, someone would yell my name out when the prescription was ready at my pharmacy. Although, people have gotten quite strict. Now you have to stand behind a certain line before you can give your prescription. And there's ways of managing it, the lineup, so that people that are near the prescription being picked up shouldn't have any more information because they just happen to be near. So all of that has to do with privacy, and all of that's covered by HIPAA. What I did see, though, is with
yeah, go ahead.
No, just with the Omnibus, it really seems to have focused quite a bit on digital. So there is certainly more refinement that's come there.
Yeah, and I would add to that a pseudo-electronic form of sending information is fax. And, again, fax machine, you do not want to have your fax machine in the middle of the waiting room where, all kinds of patient information is coming through that thing. That would certainly qualify as HIPAA violations, even though it's not, electronic per se, not when at least the way we're talking about it.
Absolutely. In one of the latest violations that I found very interesting, actually, on the fax machine, was there was a medical, I believe actually it was a clearinghouse. There was a large medical clearinghouse, and they returned their photocopiers because the lease had been completed. So they just, the photocopier leasing company came and picked them all up. The problem was that in that brand of photocopier there was a hard drive. And that hard drive kept a record of everything that had ever been copied on that thing. And I think the amount of data storage was something like going back months, if not longer. So they got slapped with an enormous fine for that breach because when it went back to the leasing company, that data wasn't wiped. So as much as we think fax machines could be secure, the technology is changing all that as well.
Okay. We had a couple of questions about encryption, one that I'll answer and one that I'll leave for you.
Sure.
You talked about the need to correct some issues, and one said, well, how does one correct the loss of a computer or a backup drive that was lost? You can't do anything about what was lost, obviously, but the one nice thing with the HIPAA rules and regulations, especially when it comes to breach notification, is that you have a potential get-out-of-jail-free card, and that's encryption. If you, I mean, we've been talking a lot about what we call data in motion, which is email. But if you are encrypting the data at rest, which is the server, your backup drives, any laptops that might have patient information on it, if those items are stolen, lost, or whatever, and they are encrypted, you do not have to notify your patients that you are not subject to the breach notification rule. Is that your understanding as well?
Absolutely the case. I think, as I said previously, the largest cause of breaches is the loss of your laptop or the loss of a thumb drive. Now, both of those systems, as well as your office computers, can be encrypted. And Dr. Lavine has a couple of products that he's recommending before that enable you very quickly to encrypt that data so that people who, even if they had access to your hard drive, even if they stole your laptop, they could not get your patient data. And that is so important because that is such a cause of violations that we see.
Yeah, I agree. Now, what about, and this was another question I had about encryption, because if you actually read through the HIPAA regulations, I could not find anything specifically that says you have to encrypt emails. On the other hand, as we just talked about, you have to take reasonable precautions to protect the confidentiality and security of patient information. And of course, let's say the HIPAA doesn't specifically say you have to encrypt, the breach notification is still there. So what is your response to that? Because, is there something that specifically says they have to encrypt an email, or is it more along the fact that they basically have to take certain precautions, and of course encryption is the most logical way of doing that?
Yeah, I've seen a couple of things. The first is there's a number of provinces and states that have very specifically called out email as must be encrypted. And in Canada there happens to be a governing body for dentists that says it must be encrypted. So there is a couple of musts in there. I'm kind of with you, Dr. Lavine, that there's probably lots of wording that implies best practices. And that type of wording, it becomes a discussion point as to whether or not sending an unsecure normal email is a best practice. And at that point, it's indefensible, in my view. Now, I have seen some authors write about how you could actually send an unsecure email, but it would require you to de-identify the information. It would require you to get multiple forms of consent from the patient, and I still think it doesn't cover you well between practices. So while I don't know that email, I haven't seen specifically email encryption in the legislation, I believe that it's a standard that needs to be met. Now, the place where I am starting to see it is in meaningful use provisions of the Obamacare regulations. So that's where I'm finding it coming up now. As if people want to be given their refund for meaningful use, there has to be encrypted email as a part of the process. So that's, but that's the sideline. Yeah.
Yeah. Just got so many questions here. Do pharmacies that we fax prescriptions to require a business associates agreement?
I would say absolutely. Now, it can be argued again that they're part of the treatment chain and therefore wouldn't necessarily required in order to deliver treatment. I'm a little more conservative than that. I prefer business associates agreement just because you want that practice in your office. So that anyone outside of your office that isn't directly someone who's bound like another practice, that you would want to make sure that that you have that agreement. Dr. Lavine, I don't know. I don't think I've specifically been asked about a pharmacy before.
Yeah, but you kind of hit my philosophy, which is that it's such an easy thing to do. I mean, you send them the agreement, they sign it, it comes back to you, you're done. It's over in 2 minutes. It's not like you're having these business associates have to go through 2 hours of training, or they've got to go through this huge audit or whatever. It's a form. It's a few pages long. They read it, they sign it, they send it back, and you're covered. And I think one of the things that you talked about, which we haven't used this exact term, but I think it's fair to say, is that when it comes to some of HIPAA and high-tech rules and regulations, it's not all black and white. There are certainly definitely some things that are very cut and dry, but as as people are seeing through the questions tonight, some of it's a kind of a gray area. It's open to interpretation, and my advice, as I'm sure Rohit's as well, is why take the chance? It's such an easy process to get that business associate agreement signed and in place, and at that point, there's no question that you're covered.
Agreed. Agreed.
Okay. We can talk about products we can use to encrypt your computer. I'm happy to talk about that. There are usually, if you can usually use an IT company. This is something that we do. Other IT companies do it as well. Normally what you're paying for is the labor and the service, not the product. If you, for example, have Windows Server 2008 or Windows 8 on any of your computers, you already have encryption built into it. It's a program called BitLocker, and you can use that. It's free. It's there. There are other ones like TrueCrypt, which are free. Now, again, sometimes it helps to have someone who knows what they're doing to set it up properly. Some systems are easier than others that allow you to restore from, like if your server has to be rebooted, or how do you access the data. But you should not have to spend a fortune. As I said, we typically will do it for our clients, but it's rare that we have to go more than 5 to 8 hours of time to encrypt the entire office. So usually you're talking less than $1,000 to get yourself completely encrypted. And compared to, as Rohit said, fines that start at $10,000 and go up to $1.5 million, it'll be the best $1,000 you ever spent. Do you have to have permission from the patient to market through email? And I think you had talked about that. There's it seems like there's a lot more regulations that, it basically, if you're sending them like, health tips or things like that, it's okay. But if it's anything you make money on, basically no. Unless can they agree to it? Can they sign a waiver that says yes, they're happy to get marketing emails from you?
Yeah. So they can. They can provide a waiver or consent to receive marketing. But it's something that you probably don't have in your practice now. It would be something that you'd want to get in an updated consent system, so that they can say, yeah, I'm fine by you sending me some promotional material. But if you don't have that information, then it's actually quite restrictive from a marketing perspective.
Okay. Do either of you have recommendations for off-site backup companies? Well, this is one of the things we've been doing for our clients for about 5 years now. So yes, we call ours Data Protect. I'm not here to market our services at all, but certainly if you want, when you sign out of the webinar tonight, there's going to be a real short 2-question survey. Do you want me to follow up with you? Do you want Rohit to follow up with you? Or both? Just indicate on there if you do, and someone from my office, someone from his office will certainly follow up, and we're happy to talk about the ways that we can help you. Is a supply company sales rep required to sign a VA agreement?
It depends on, that's a great question, by the way. I can't tell you how many times I've been in a surgery where there has been an implant rep who's had all sorts of communications with that surgeon about that particular patient. With unequivocally in that scenario, you would have to have them sign that business associates agreement. because they are directly involved with that patient treatment.
Yeah.
So I would say absolutely. Now there are some reps that will simply come in, speak to your front desk staff, and want to make sure you've got enough supplies. For that type of interaction, they wouldn't be exposed to patient information, and so I wouldn't see the need in that example to have a business associates agreement with them.
Okay. A few more questions here about the secure mail. What if you have multiple employees that are using the system? Do each one of them have to be paying $29.99 a month? Or
No, I'm glad you brought that up. So we provide, our typical scenario is the dentists, we have one dentist and 4 assistants or other people that work with that dentist that are all included for that same fee. So for $29.99, there's one dentist plus 4 staff members.
Okay. My Invisalign rep reviews my patient cases from outside my office and makes comments to me through emails. Well, I would say that's a great example of someone that you need a BA agreement with, and you need to be using a secure mail because that definitely would qualify on both those levels.
Absolutely. In fact, we tend to work with quite a few Invisalign practices, as a matter of fact, for that very reason, because there is a lot of back and forth.
Yeah. Can an IT person make Outlook encrypted? And that's kind of a loaded question. I mean, there certainly are some third-party add-ons there. But again, one of the things that Rohit talked about, it's not really necessarily what goes on in your office. It's what happens to that email once it goes to all the other servers. And he talked about how there's multiple steps in the chain. They're called hops. And it's basically that information is hopping from one server to the other. You've got no control over that. So even though if you might have some type of add-on that's encrypting it on your end, the fact is that, unless the recipient has some type of decryption key or, you're going through all this rigmarole, something like secure mail is obviously a significantly easier method of handling that in my mind. What if you talked about 25 people that they can have in their network? What if one of those people is already using secure mail? Does that count against it?
No, it doesn't. It doesn't count against them at all.
Okay. And is there a limit to how much data that, like, let's say that, over a month you do like 10 gigs or 20 gigs? Do they get charged extra for that? I
think somewhere, interestingly, someone asked me that same question today. I think somewhere in our user agreement there is some maximum that we wouldn't want someone to abuse the system, for example, and send movies back and forth and do all sorts of things. And so all I can tell you is we've never had anyone come close on our system yet, but I'll review that, and if someone wants to write that specific question, I'll get an answer back. I think we've got something in there that just prevents abuse, much like your cable provider and your cell phone provider. Everybody's kind of got these abuse clauses, and in that case, we probably have something, yeah. But like I said, nobody's ever had it.
Okay, for the notice of privacy practices,
yeah.
If they signed one before the Omnibus rules went into effect, is the new one significantly different that they should sign another one?
It would depend on when they signed the last one, or it's more something that they're providing. And so I would take a look at the new one, and like I said, we'll send it to you. And you may want to update everything. There are some differences in terms of how the patient can ask for their information, the deadlines around those information, the method that you have to provide, and how much you can charge for it. All of that information should be in the Notice of Privacy Practices, and that information has changed since the last update because of the Omnibus rules.
Yep. What about some of these appointment reminder systems? I'm sure many people are using ones like Demandforce, and there's other ones out there. Yeah. Because those are being sent typically through email. Do those have to be encrypted, or was that a scenario where you would need to have the patient sign a waiver, or what's been your experience with those types of systems?
Yeah, my experience with those is, first of all, you do want to have consent from the patient to send them that type of information. So on their consent form, you should it should address that particular type of information, saying that we will from time to time be sending you appointment reminders, or however you might want to word that. So they should consent to that, because many people might be sharing that email, and you want to make sure that whoever's receiving that email has consented to receiving that email. Where I've seen quite a bit of discussion now, Dr. Lavine, around that is that's acceptable as long as there's not notices of what actual treatment is. So if there's, for example, prescription information in there, make sure you don't take this prescription because of what treatment you're going to have, or a treatment notice. So for example, you're going to be coming in for this treatment and this treatment and this treatment. That's where that edge starts to get blurry. And so I think, this is something that I think those companies that are providing that, especially for the big ones, I'm sure they've got this stuff well thought through. But it's something I'd be watching for smaller companies, for sure, because I know there's quite a few that do this type of appointment reminder now.
Yeah. There's so many great questions here. I want to make sure we try to get as many. What about recall postcards? Would those be covered by HIPAA?
Absolutely. Yeah. It's interesting because someone once gave me the analogy where sending an email is like sending a patient record through, like writing it on a postcard and sending it through post so that anybody along the chain can read it. So HIPAA is very concerned about the type of information that you're sending in on a postcard because anybody along that chain can read it. HIPAA's concerned about what's on the shipping label. So if you're getting, I know a couple of labs, for example, that have changed their practice because they used to write on the shipping label have the patient name on it. And so these practices are changing because HIPAA does cover all that stuff. Now again, with the recall postcard, I take the same view as I would from an electronic standpoint, which is as long as it's just a reminder, you still want to make sure that you have their consent to send you that information. And secondly, you want to make sure that nothing's in there about don't take this prescription or do take that prescription or whatever details there are about that treatment. You'd want to be careful around it. Otherwise, an envelope is the right way to send that information, or some sort of a secure system.
Yeah. Can we post daily schedules with names and phone numbers and operatories? I would say no. I've been telling people for years you can't pull up your scheduler on your screen and with other patient names on it. I would assume that would apply to printed schedules as well.
Big time. Yeah, you never want that available.
Let's see. What about logging into the office computer from home through LogMeIn? And I can answer that one.
Yeah.
Because HIPAA actually does address some of those issues of remote access. Obviously, this is something that a lot of people use if you have multiple offices or you're at home on the weekend and a patient calls and you want to access it. There's two things that I think are really key factors in the remote access software that you're using. Number one, there has to be an audit trail. In other words, that you would know specifically who logged in based on their username and password, their IP address, that you can track exactly when someone logged in. The second thing, which is really kind of important for us, especially as an IT company, is that there's some type of auto log-off built into it, that within a set period of time of inactivity, it might be 30 minutes, an hour, whatever the case is, that it's going to log it out rather than someone logs in and that thing stays open for days. Of course, anybody walking by the computer of the person that logged in remotely can see what's there. So certainly remote access is, can be HIPAA compliant, but you need to be a little bit careful. There's a lot of free programs out there that wouldn't necessarily meet those criteria.
Agreed. Yep.
Let's see. We only got a few more minutes here, and unfortunately, we're not going to get to every question. But I would remind people that we are. Every question is recorded. Rohit is going to get a list of all the questions and who asked them. I'm going to have that list as well, and we're certainly going to do our best to follow up. What about if you're getting, say, subs from a dental agency, hygiene, front desk, or whatever? Would the agency need to sign the BA agreement, or would you just have the hygienist himself sign it, or any thoughts on that?
Yeah, I mean, I think you'd want it with the agency because you would want it just for them to be covered. And having a new person sign one of these agreements every time they walk in is a bit of a sidetrack. So I think if you signed it with the agency and those people were hired by that agency, they would have the agreements necessary with those individuals in order to make that work. Now, if someone's not from an agency and is someone that you use regularly, then you would want to sign it with them directly.
Okay. What about mobile? That seems to be a real hotbed of potential problems. People are using texting. They're sending stuff from their mobile phones. Do you have any thoughts about the need for security and privacy with mobile devices?
The data that we're seeing is that there's thousands of cell phones lost or stolen every week in North America. So it's absolutely not one place that you do not want to have any patient images. I know there's some people that when I go to visit their practice, they actually take pictures of their patient with their latest iPhone or their iPad. That's not to be done. One, because it doesn't have that encryption, so that data is available for anybody who finds that phone or that iPad. The second is, if you've connected to the iCloud or one of these other automated systems, it will copy it from your unsecured device and put it on your unsecured cloud. And so it's taken a problem and made it worse. And Google does the same thing with their Android and automatic uploads as well. So it's not something you want to do. Now, I do know that on the Android system, there are ways of encrypting it now, which would solve that problem. But the question is, how do you get it off of there? If you're meant to use email to send something that has been encrypted, you've just violated your own rule. And so you would want to use secure mail with an encrypted phone if you want to have patient data on there.
Okay. Now, for people using the secure mail, they don't have to get a new email address, correct? You can
No.
continue using your old email address?
Absolutely. We send all those notices to your normal email address, and what we've got then is a link at the bottom of the email that says click here to the recipient. So they get it on their regular device. They click on that link. And once they click on that link, they'll be taken to the secure mail website. They log in with their username and password, and they can see all of the confidential information. From our perspective, the reason that's really valuable is now we've got a real audit control over who saw that data, when they saw it, and what they did with it. So if they forwarded that secure mail onto another person in their practice, then we know that. We can provide that audit trail back to you if for example, there's a breach.
Okay. What about, like, a lot of offices use not necessarily temps, but they have students that come in and shadow, for example. A lot of them will have, there'll be local schools that want to come in and learn how to assist or shadow employees. Should they be signing VA agreements as well?
Absolutely. The worst thing that can happen, the thing that will kill those programs, is if someone's come into your office, they happen to see a patient they know, and they didn't understand the confidentiality required because of that. Because unless it's made clear, part of it is just about having to have that conversation with that student around doctor-patient confidentiality and what it means. And the associate's agreement allows them to have that conversation because that information really is at the core of what you need to protect in your practice. And so I would say without a doubt you would want to do that.
Okay. Now, one of the things I'm noticing a couple of you mentioned here that we posted a link, which is www.hhs.gov/HIPAA, which currently is not seem to be a live link. That's the beauty of websites is that they change their URL. So I know when we send out the information, the packets, I know that Rohit and his team will double check that,
Yeah.
what the actual URL is supposed to be. I notice a few people are saying that they can't get that.
Sure.
I think we only have time for another couple of questions. What about people that now are using their websites or social media to post before and after pictures, for example? I would assume that having some type of agreement is pretty mandatory with those patients.
Oh yeah, yeah. I mean, I think I've seen cases now where I would have considered it very difficult to identify the patient, even because it was just a shot of the mouth. But again, I would say that the most valuable thing to have is the full smile of the individual before and after, and not just the mouth. And in those cases, you want to make sure you're absolutely clear in their consent and their release that these pictures will be used for this purpose, and they're signing away the right to come after you for that purpose. Those releases got to be airtight.
Yeah, I would agree. So we're out of time, and I've got a great idea to think about here, Rohit.
Yeah.
We had done a webinar not too long, a few months ago. What was it, the 5 burning HIPAA questions that you have?
Yeah, I think we had the 5 things
like
you do. Yeah, the 5 things you do every day that are not HIPAA compliant. I think there was that one.
Right. And wasn't there one on the burning questions? I think maybe we had 10 of those.
Yeah, there's 10 burning questions. Yeah.
I'm going to throw out a great idea because we just have so many questions that we couldn't get to, and I'm thinking maybe our next webinar will talk for 5 to 10 minutes and take some of the best questions that we've gotten so far. It might be 30 or 40 questions, and just hit those because there's just so many questions that people have, and I think that the content was fantastic tonight, and there's just so many things that you have to know about, and I would certainly encourage people. One of the reasons I like working with Rohit is that in a lot of ways we work together. We share information. We both tend to offer services that don't step on each other's toes. Many of you that have worked with me in the past know that I'm a big advocate of encryption and online backup and local backup and other things that you can be doing to get yourself HIPAA compliant. Certainly, as Rohit had mentioned, his area of expertise is really on the mail and web portals and all the things associated with that. And both of us can be great resources for you, and I would certainly encourage people to pick our brains. As I said, when you log out of the webinar tonight, just indicate if you'd like either one of us to follow up with you. We'd be more than happy to do that. Rohit has very graciously, for those of you who are coming in late, has very graciously agreed to send everyone a packet of information with all of the forms that he's been talking about tonight that, it'll be there for you for your use. So you modify them if you need to, but you can probably use them right out of the box. So, Rohit, I just want to thank you so much for joining us this evening. I think these webinars are very informational. I think sometimes they raise as many questions as we can answer, and maybe we should reconsider what the next one should be. But certainly, this was great information as always, and we appreciate your time and your expertise.
Oh, my pleasure. Thanks very much to the audience for sticking with us. It can be a pretty thick hour and a half. And thanks to you, Dr. Lavine, for gathering everybody. I like your idea about how do we just have a question and answer session, because there are so many questions and lots of things that I don't think about when we're putting together a presentation, which are probably we could answer reasonably easily, but they're just not on my list. So love the idea. Let's figure out if we can do that. Yeah.
Well, as many of you know, we do these webinars on a regular basis. I'm typically doing all kinds of topics. This one was very well attended, a lot of interest in it. Unfortunately, with the new Omnibus Rules, this is not, well, let's get around to when we feel like it. You're already too late. So there's no time like the present to get started. So I want to thank all of you for taking time out of your busy schedule to join us. We are definitely going to be following up on this topic, because I think it is so critical for practices to be up on it. And look for more information about non-HIPAA webinars, but also more on HIPAA, because I think we have a topic here that really requires a lot more information out there. Thank you all for joining us. It was a pleasure to have you here, and we look forward to seeing you all on future webinars. Good night,
Thanks, everyone. Bye-bye.